viewers, I'm Advocate K. Rawat from Lexis and Company. Today we're going to talk about the kinds of jurisdiction under Civil Procedure Code 1908. So number one, let's talk about territorial or local jurisdiction. Under this territorial or local jurisdiction, the geographical limits of a court's authority are clearly mentioned and specified. It cannot exercise authority beyond that geographical territorial limit. For example, if a certain crime is committed in Madhya Pradesh, only the courts of law within the borders of Madhya Pradesh can hear and decide the case. Furthermore, Section 16 of the Code of Civil Procedure explains the territorial jurisdiction on the grounds of the location of the immovable property. In the case of Harshad Chiman Lal Modi versus DLF Universal Limited, the court interpreted Section 69 that the suit pertaining to immovable property should be brought to the court. The court does not have the power to decide the rights of property which are not situated. However, the court can still pass a relief if the opposite party agrees to try the suit in such a case. Now, let's talk about the pecuniary jurisdiction. Pecuniary means related to capital. It approaches the question of whether the court is competent to try the case of the financial value. The court allows analysis the case unless the suit's value exceeds the financial limit of the court. Section 15 of the Code of Civil Procedure commands the organization of the suit in the court of the law trade. It refers to the pecuniary jurisdiction of civil court. It is a course of the method and it does not affect the jurisdiction of the court. The main objective of establishing pecuniary jurisdiction is to prevent the court of a higher level from getting burdened and to provide assistance to the parties. Now, jurisdiction as per the subject matter. The subject matter can be defined as the authority vested in a court to understand and try the cases concerning a special type of subject matter. In other words, it means that some courts are banned from hearing cases of a certain nature. No question of choices can be decided by the court which do not have subject matter jurisdiction. Section 21 of the Code of Civil Procedure is related to the stage challenging the jurisdiction. For example, Ranveer, a resident of Sonipat, bought a food item of AA brand that was plagued with pest. He should prosecute Lexis and Company in Sonipat District Forum rather than District Civil Court of Sonipat. Now, original and appellate jurisdiction. Appellate jurisdiction refers to the court's authority to review or rehearsal the cases and have been already decided in the lower courts. In the Indian circumstances, both the High Court and Supreme Court have the appellate jurisdiction to take the subjects that are brought in the form of appeal. Original jurisdictions refer to the court's authority to take notice of cases that could be decided in the case court in the first instance itself. Unlike appellate jurisdiction wherein courts reviews the previously decided matters, here the cases are heard afresh. I hope you are pretty much clear with the jurisdiction part, and if not so, then do let me know in the comment section regarding all your doubts and queries, and I will see you guys super soon in my next video with some other legal topic.